All seems not to be well with the People's Democratic Party (PDP) in Ogun State, with fresh case instituted against the party. A governing aspirant in the state, Sowunmi, has approached the Court of Appeal sitting in Ibadan to set aside the judgment of Justice A.A. Akinyemi of the Ogun State High Court, which struck out a suit seeking the dissolution of the state party Excos. Sowunmi, who had earlier approached the court to challenge a statement credited to fellow contestant Honorable Ladi Adibutu that his nomination form was procured for him by members of the state Excos. Sowunmi, in a press conference in Abeokuta, explained that he prayed the court to dissolve the state Excos on the ongoing grounds of violation of their oath of office and bias, seeking interlocutory injunction restraining the Excos from conducting the World and the State Congress. Sowunmi, in his notice of appeal, claimed that the judge was in a grave error when he held that only the Federal High Court can exercise jurisdiction in addressing the appellant's complaint.
Ideally, independence, integrity, fairness, equity, and justness will naturally be expected. But my rival, one of my rivals, the President of Honorable Ladi Adibutu, was on radio that had also live stream, where he said very clearly that the Excos, who have very important roles to play in preparing the grounds for primaries, upon saying that, which I consider to be a bit odd, I caused my lawyers to write the party at the National, bringing up this very serious breach, in my opinion, which I then offered them possibly 2 course of action.
Sowunmi has also written to the National Working Committee of the party seeking the dissolution of the state executive over alleged violation of their oath of office. The governorship aspirant accused the state Excos of the party of being biased and compromising the process of the forthcoming governorship primary election in the state. Sowunmi, in a letter dated Friday, May 20, and made available to journalists, warned that if the Excos is allowed to conduct the primary election, it would amount to inauguratory and a situation whereby the party may not have a candidate at the 2023 general elections.
The State High Court could deal with it because it was not a pre-election issue. Well, all of the expectations of filing of notices and all that was done. The case came up finally yesterday, and in the wisdom of the learned judge, he ruled that he didn't have jurisdiction. When we saw what he had written, we felt that that was not exactly correct, and it was not exactly the position of the law